everyone, and welcome to today's webinar, Retaining Foreign National Talent, a Green Card Guide for HR Professionals. I'm Emily Jenkins, Marketing Director here at Dominion Payroll, and we're so glad you could join us as we learn more about Green Card sponsorship policies. And today's presenter is Colleen Molnar. Colleen is a North Carolina Board Certified Immigration Law Specialist and a partner at Garfunkel Immigration Law Firm. Before we dive in, just a quick reminder, today's session is being recorded and you'll receive a copy of the recording after the presentation. If you have any questions at all, feel free to drop them in the questions chat and we'll be sure to address them after the presentation. And with that, let's go ahead and jump in. Welcome, Colleen.
Thank you, Emily. I am excited to be here to talk with y'all about retaining foreign national talent, specifically from the Green Card immigration sponsorship perspective for HR professionals. As Emily mentioned, I'm a partner at Garfunkel Immigration Law Firm. Just a little bit about us. We are about 28 years old, and we are one of the largest firms in the Southeast dedicated to the practice exclusively of immigration law. We represent companies and businesses in a variety of industries and across the globe, including in healthcare, clinical research, technology, manufacturing. And we also do immigration for individuals, so from family-based sponsorship, those who are getting married to U.S. citizens or engaged to U.S. citizens, or sponsoring for children or other dependents. And then we also do smaller employment-based immigration as well. So folks who want to come over as entrepreneurs and invest in companies and create job opportunities as well. Also, as Emily said, I am board certified in immigration law here in North Carolina by the NC State Bar. I am in my 12th year of practice, and I've been with Garfunkel Immigration my entire career. I currently manage our healthcare immigration practice. So I work with healthcare clients, including hospitals, systems, and then individuals in sponsoring physicians, nurses, therapists, and then also folks who work in the IT field in the healthcare industry. But I also have a lot of immigration experience across other sectors, including automotive and manufacturing and technology. Before we get into the substance of today, just a disclaimer that everything that we talk about today is just general information provided only in connection with this webinar. It does not constitute legal advice. Before you take any sort of action, just make sure you consult with immigration counsel or attorney before you take action on any legal matter. So today this is just a little run through of what we'll talk about. First, we'll talk about some of the fundamentals of immigrant visas or green cards, and then the processing times and the different categories of green card sponsorship, some best practices for employers, and then there will be opportunity for questions, and I'll provide my contact information as well if anyone wants to contact me offline. So first things first, just some fundamental information on what exactly is an immigrant visa or what exactly is a green card. An immigrant visa is a green card. So you'll hear me use those terms interchangeably. They are the exact same thing, or they mean the exact same thing. They both get an individual to permanent residence here in the United States. It is different from a non-immigrant visa, which allows folks to come here temporarily. So there are non-immigrant visas for folks to come here for pleasure or for tourism, like going to Disney World. And then there are work visas, work non-immigrant visas. Those allow folks to come here temporarily. They have a limited length of time that they are allowed to be here, and then it maxes out. So the immigrant visa or the green card allows foreign nationals to be here permanently or indefinitely. The principal individual who's being sponsored for a green card, they can also have their dependents be sponsored for a green card or come over on a green card as well. A dependent by immigration law is defined as your spouse that you're legally married to, and any children who are unmarried and under the age of 21. So if you have, a 20-year-old who's married, then they would not qualify to be sponsored as your child or tag along with you on your green card. The benefit of a green card is that it gives no restrictions on work or on travel. So as long as it is valid, they're typically issued for up to 10 years. And as long as it is valid, it can be used to come in and out of the country. And it can be used for I-9 purposes for work authorization. Generally, to have a green card, you need sponsorship. And I'll talk a little bit about that next. But the sponsorship should come from an individual, in which case it's usually a family-based petition, or from an employer, which of course is what we're going to be talking about today. And then finally, green card is required before you can actually apply for U.S. citizenships, 5 years in most cases. In some situations, it's less. So you have a lot of times you'll have folks come in on a non-immigrant visa, work visa like an H-1B visa temporarily, then in the meantime get sponsored by your employer for the green card, and then after 5 years of having your green card, then applying for citizenship. And just by some more fundamentals or definition, an immigrant visa and green card, I mentioned I'm going to use those terms interchangeably. They're generally talking about the same thing, meaning someone is coming here to be a lawful permanent resident. The immigrant visa is when the individual is outside of the United States and coming into the United States to get a green card. So first they have to get their immigrant visa stamped in their passport, and then they come in on that immigrant visa, and the actual green card document is issued and given to the employee after they come in on that immigrant visa stamp. Whereas the green card is the actual document that serves as their lawful permanent residence and ability to come in, travel in and out with it, and then used for I-9 purposes as well. So I mentioned before that that generally a green card requires folks to be sponsored. There are generally 5 different pathways to getting a green card. One is family-based. Again, this is when you have, for example, a U.S. citizen spouse who wants to sponsor their foreign national husband or wife for a green card. It can also be for other immediate family members, or children. There's a whole list of categories within family-based that qualify for sponsorship under this preference category. There's humanitarian. You hear a lot about this category in the news. So asylum is an example of a humanitarian way to get a green card. And then there's an investment green card, which is used by individuals who want to invest a certain amount of money into a company here in the United States that will create job opportunity. The diversity lottery is exactly what it sounds like. At the end of every fiscal year, the government will allow you to, or the beginning of every fiscal year, the government will allow folks to put their name in and apply, and then it's literally just a lottery. And whoever gets selected, then they can complete the green card process and then come over on a green card or immigrant visa. And then finally, employment-based. And there are different categories within the employment-based section within which folks can be sponsored, which we'll talk about. So a lot of employers, especially those who are new to hiring foreign nationals, they want to know the benefits. So really, why should I sponsor a green card? And there are several reasons. One is for retaining talent. Green card sponsorship is generally a very strong signal of commitment to your employees. It could encourage them to stay with the company for the long haul. It gives them job security, which in turn is going to reduce turnover rates. And then additionally, it can attract top tier talent in highly competitive fields like technology and healthcare and engineering. And then skill retention also. So by sponsoring green cards and giving that commitment to your foreign national employees, it's going to ensure that your skills and expertise are retained within the company and maintain a competitive edge. Employee commitment and loyalty. Having a immigration policy where employers will sponsor green cards, it's a sign of loyalty and commitment to your employees, which I think will in turn and is more likely to have your employees more committed and be more likely to engage and motivated and productive. There's work authorization flexibility with green cards. As I mentioned before, you can use a green card to work generally anywhere you want. So once you have the green card, or once your employee has the green card, you no longer have to continue to maintain their non-immigrant work visa if they're already here in the U.S. and working pursuant to that temporary status like an H-1B or a TN or an O or an L. It also reduces the risk of having any work disruptions due to those visa maximum expirations or changes. Like I mentioned before, with the temporary non-immigrant visas, they have an allotted period of time within which they can stay with you and work with you until they have a green card. So having the green card, again, it avoids it avoids you having to continue to maintain that and keep filing over and over again. And then it also reduces the risk of work disruptions due to those expirations and helps ensure smoother business operations. Similarly, with long-term planning and growth, having a green card, it sort of future-proofs your workforce. Giving a stable workforce allows for more effective long-term planning and growth strategies. Again, avoids those visa limits. Enhanced employment opportunities. So by having a green card sponsorship policy or immigration policy, I think it helps attract a wider pool of talent. It gives you access to a broader range of candidates globally, which also can help bring foster more diverse perspectives in your workplace as well. Corporate social responsibility is a sign of the company's willingness to support employees. I have one client who in the past has me review their green card sponsorship policy year after year to make sure that it's foreign national friendly. They want to ensure that it's competitive with other companies that we see and clients that we see and what their policies are. So having that green card sponsorship policy, again, it demonstrates support and creates an inclusive atmosphere. And then finally, as I've been mentioning, market competitiveness. So it gives you a competitive edge in the market. Some individuals, especially those from countries where there's a long wait for a green card, they're probably going to be interviewing and looking for companies that do have a sponsorship policy because, again, they want to have that long-term planning and growth for themselves, strategically, and also the flexibility to be able to stay in the U.S. and not have to depart the U.S. at the end of their sponsorship. So there are a lot of government agencies that deal with immigration in general. They all fall under the Department of Homeland Security. The two main ones that you'll work with and we work with when it comes to green cards is the Department of Labor. They review the first step of the green card process in many cases for employment-based petitions. And then also the U.S. Citizenship and Immigration Services, or USCIS. They are the ones that oversee lawful immigration to the U.S. They adjudicate visa petitions. So even if you're filing for a non-immigrant visa petition, the USCIS is the one that's reviewing it and approving it. Steps 2 and steps 3 of the green card process, which we'll talk about, the USCIS reviews those, and they are the ones that make the decision. Occasionally, depending on where your employee is at the time of sponsorship, you might also be dealing with the Department of State. The Department of State is the agency that oversees the consular and embassy affairs and operations. And they are the ones that will interview the employee and issue that immigrant visa stamp in the passport, which in turn allows them to come essentially knock on the door of the United States, say, let me in, I have green card sponsorship. And once they come in, they get the actual green card in the mail. So that's occasionally, though. Most of the time, in my experience, in our firm's experience, our clients and employers are sponsoring their existing employee workforce because a lot of employers want to, they've had an opportunity and a chance to work with the employee and evaluate their performance before they commit to green card sponsorship. So more times than not, the employee is actually here in the United States and we're going through these two agencies and not dealing with the Department of State, but occasionally you will. So there are 5 different ways that you can qualify for a green card in the employment-based immigrant visa category. We call these preference categories. EB stands for employment based, so it's EB1, EB2, 3, 4, and 5. We're going to focus on EB1 through 3 today because those are the ones that generally require employer sponsorship, whereas 4 and 5 are usually done individually or religious workers, which likely aren't applicable to the audience here. So the EB1 is for priority workers. Those are for multinational managers and executives, so like intercompany transferees. If you have employees who are here on L1 visas, they might be good candidates for the EB1 classification. There's also 2 other subcategories of EB1. Those are for individuals of extraordinary ability and individuals or outstanding professors and researchers. And I'll go through these in a little bit more detail in the subsequent slides. Employment-based 2 is for folks whose jobs require advanced degrees, and they have those advanced degrees. So the category that you fall into mostly depends, especially EB2 and EB3, it depends on what the job requires and not necessarily the highest level of education and degree that the employee has. For example, EB3 is for professionals, so those who have or those whose jobs require a bachelor's degree, and then skilled and unskilled workers. So basically anything less than a bachelor's degree would fall under here as well. So if you have an individual whose job, they're an engineer, for example, and their job requires a bachelor's degree, minimally requires a bachelor's degree, but the employee has a master's degree, they're still going to be in this EB3 category because it's what the job requires and not necessarily what the employee, him or herself, has. Overall, and just in general, about all of those, specifically those 3 categories, EB1, 2, and 3, they are position and location specific. In most cases, there are some limited exceptions, and they are also employer specific. Again, there are some limited exceptions to that. So when you're filing for a green card, or when you're filing for an employee for a green card, you're looking to the future. You're looking to what the future job is going to be for this employee, not necessarily what they hold right now, but what they might be holding in 3, 4, 5, 10 years, whatever the outlook is for or timeline for their green card, depending on, what the, I'll talk about this too, what the visa bulletin says in terms of the timeline for when a green card could be issued to this individual. So again, when we're talking about these categories, 1, 2, and 3, we're looking at the position offered to them when they are a permanent resident. And then also there is a prevailing wage requirement. So at least in EB1 or EB2 and EB3, we have to file on the employer's behalf, we file a wage determination with the Department of Labor. The Department of Labor comes back and tells us what wage or what the minimum wage is that the employer has to pay to that employee when they get their green card. So again, it's in the future, not necessarily what you have to pay them right now, but when they actually get their green card. Usually it's not an issue because we're talking about a few years out in the future. And the Department of Labor determines what that wage rate is going to be based on the minimum requirements for the position. So if there's a degree and years of experience, it's going to be a higher wage. If the employee is supervising folks or if travel is required for the job, then they might increase the wage in that scenario as well. So you've heard me talk a lot about it being 1, 2, and 3, or steps 1, 2, and 3. In general, it is a 3-step process. There are some limited exceptions to that, and I'll tell you where. But the first step in general is called the labor certification process or the PERM process. This is the step that goes through the Department of Labor, and it requires you as the U.S. employer to test the labor market. So you are actually putting recruitment and advertisements out there for this position, and you are doing that to ensure that there are no qualified, willing, available, qualified U.S. workers for the position and able. And you had to interview folks, review resumes, interview folks who look like they might qualify for it, and actually show how they are disqualified for the job. The second step, assuming this step passes, the second step is the I-140 immigrant visa petition. This is the step that is filed with the Immigration Service, and this is where you, as the U.S. employer, you are filing a petition to the Immigration Service saying, we've gone through step one, we've recruited, we haven't found anyone, it's been certified by the Department of Labor, and now we are petitioning to you, the Immigration Service, to allow us to sponsor them for a green card and for you to grant them a green card. Assuming the Immigration Service approves that step, you also have to show how the employee, him or herself, meets all of the minimum requirements for the position that are outlined in step one. So they kind of work in tandem together. Once this is approved, and if a green card or immigrant visa is available for the individual, for the employee, then you can move on to step three. And I always tell folks that step three is really the individual, the employee's application to the government. It's called an I-485 adjustment of status application, or if you're abroad, then you're applying for your immigrant visa at the U.S. consulate, but which goes through the Department of State. Otherwise, the adjustment of status application, that's where it goes through USCIS. And this is, again, their individual application in the government. It is a very long application. It used to be longer, but it's dwindled down a little bit. It might get longer over these next couple of years, but it requires the employee to put all of their residential history, their work history, immigration history. They have to submit medical exams, etc. And it's really the employee's application to the government saying, I pass all the tests. There is nothing in the law that makes me inadmissible or ineligible for a green card based on medical grounds or health grounds, criminal grounds, immigration violations, etc. So I like to think of step one is the recruitment, the labor market test. Step two is the employer's petition driven by the employer. Step one is also driven by the employer. And then step three is really driven by the employee. That is his or her own application to the government, and it rarely involves the employer. So a little bit more about step one, that perm process. Currently, the processing times are very long. The Department of Labor is really our longest step of the three-step process. As I mentioned, it requires proof of no minimally qualified U.S. workers through that labor market test. There are specific methods of advertising and recruitment that are outlined in the law. It's very antiquated. Two of the recruitment methods that are required are ads in a Sunday newspaper of general circulation, which I guess it could be a good thing because you're probably going to get less applicants and attract less folks through that type of advertising. But a lot of people think we're kidding when we say that, but we're not. The methods of advertising have to occur within 30 to 180 days before we can actually file the perm application. And as I mentioned before, too, that prevailing wage determination happens at this step, and we usually have to have the prevailing wage determination before you start the labor market test. Or it's a good idea to, it's a best practice too. We can, you can be flexible in circumstances, especially if you have an employee who's got a timing issue with their non-immigrant visa. But the prevailing wage determination right now is taking about 6 months. So if you add 6 months on top of the processing time for the actual perm, we're telling folks to budget for about 2 years from start to finish for that perm process. So right now it's taking a very long time. Unfortunately, we don't see processing times are going to get shorter in the near future. Step two, that immigrant petition, so the employer's petition, I-140 to the Immigration Service. Current processing time is about 6 months, but you can premium process that, meaning you can pay an additional government filing fee for the government to adjudicate it in a quicker period of time, which is generally about 15 business days. In some different cases, it's up to 30 or 45 days. And again, the benefits of that can just depend on if your employee has any specific timing issues. We generally advise on business need, if there's a business need to avoid any disruptions in work or employment lapses. then it might benefit you as the employer and the employee to request premium processing. Step 3, the processing time varies. The employee's application, individual application to the government. This is also where the employee can add their dependents, so their spouses and children under the age of 21. Back under Trump's first administration, he started requiring in-person interviews for employment-based green card individuals at local USCIS offices. Once COVID hit, those were informally rolled back. We have been seeing, since he took office again, we have been seeing more and more interview invitations to USCIS. It has not been consistent in our firm, at least, but we have heard reports that more and more companies and individuals are getting interviews with USCIS. So that could come back. But generally speaking, it's been required, or if you're invited to it, it's required before the Immigration Service makes a decision on the case. They're really inviting you and any dependents applying. When I say you, I mean the employee and any dependents applying with them. They're coming in there, and the officer is reviewing the application with them and confirming that nothing has changed since the filing, confirming that they still intend to take the job that you have sponsored them for, and then also confirming all of those admissibility requirements. So again, nothing in their background makes them ineligible for a green card. If there is something in their background, they are more likely to get called in for an interview here. So if they have any criminal history or encounter with law enforcement, any health-related issues, or any other sort of flag on their file, especially with immigration history as well and maintenance of status, then that's when we're likely to see an interview with Immigration Service as well. Step 3, why I say processing times vary, is because it can only be filed and it can only be approved if the employee's priority date is current, meaning their place in line is current and a green card is available to them. And what that means, in a nutshell, the Department of State, they issue this visa bulletin every single month, which is basically an outlook of what individuals in which employment-based preference category and in these countries of birth have green cards available to them, because our green card system is based on supply and demand. So each preference category has its own, and country has its own allotment, and the demand is a lot higher than the supply in the past few years, or a lot of times in most historically, it's the demand is higher than the supply, especially for folks who are born in China and India. But in the past couple of years, especially since COVID, we've seen the demand a lot higher than the supply in a lot of these other categories, because normally it's current in the EB2 and EB3 categories. So right here is where you have the preference categories. So 1, 2, and 3 is what we're talking about today. So this is sort of a redacted visa bulletin and snapshot of the June, what's out there right now for June 2025. This row is country of birth. So they break it out by China, India, Mexico, Philippines. And if you're not born in one of those 4 countries, then you fall under this one, all chargeability areas. And then these dates are the priority dates. Your employee's priority date is the date that the first step of the green card process was filed. So if your employee falls in an EB2 or an EB3 category where they required to file a perm and test the labor market, the date that you file that perm is going to be their priority date. So if you have an employee from Germany, and you filed their perm application on October 1st of 2023, and it was a perm position or a green card position in EB2 classification, then their priority date's current. It has to be on or before the priority date listed in here in order to apply for that last step of your green card process. A C means that green cards are available in that preference category. So I mentioned a minute ago that normally, historically, it's a C here and here. But the demand, as I mentioned, has been far exceeding the supply in recent years. So we've been seeing these cutoff dates, and as a result, we're seeing a longer period of waiting time for folks, really with all countries of birth, to get their green cards. Normally it's India and China employees that's taking the longest, but again, now it's mostly everyone. You'll see here in the EB1 row, they have the shortest wait for the most part. So it's current for everyone except for China and for India. And right now for China, it's about a 2.5-year wait. India, it's about a 3-year wait. So if an employee can get into the EB1 category as either a multinational manager or executive or extraordinary ability or outstanding professor or researcher, we always try to go that route because, again, that's going to get them their green card much faster, which in turn is going to bring you the advantages and benefits of having a green card employee. And the Department of State, they release this usually about the second or so week of every single month. So you get about a month's outlook every single month. So it's very hard to predict, but we are able to really see what the trends have been like in each government fiscal year, which is when it restarts, these numbers restart, and then advise based on that what the trends have been. So I mentioned EB1, the employment-based preference category 1 is for priority workers. It's broken down into internationals, managers, and executives, outstanding professors and researchers, and folks of extraordinary ability. So the international managers and executives, this is for individuals, employees who have been employed by an affiliated company abroad in a managerial or executive position, and they're coming to your company, or they're going to be employed on a full-time permanent basis in a managerial or executive position. So if you have employees who are here on an L1A, if you're a global company and have employees on an L1A visa, this is likely going to be a good strategy to look out for them. But the trick is there can be L1 employees who were not in a managerial or executive position abroad, so that can be tricky for some L1 employees as well. And then the outstanding professors and researchers category, that's really designed for individuals who are recognized internationally for their exceptional academic achievements in a specific field. So overall, they have to be internationally recognized as outstanding in a specific academic field. They have to have at least 3 years of experience in teaching or research in that academic area. And then especially if you're doing a professor, they have to be in a tenure track teaching or a comparable research position at a university or an institution of higher education. Or if they're being sponsored by a private employer, then you as the employer have to have at least 3 full-time researchers and documented accomplishments in the field, and then the position that you're sponsoring them for has to be a research position. The Immigration Service has a long list of eligibility criteria to help prove that the employee is recognized internationally for the exceptional academic achievements in their field. A lot of that evidence includes, and you only have to prove 2 of them for that subcategory, but you have to show receipt of major prizes or awards for outstanding achievement, membership in associations that require outstanding achievements, published material and professional publications, participating as a judge of the work of others, original work, and then scholarly articles as well. The other subcategory for EB1 is individuals of extraordinary ability. So this is intended for folks who have achieved a level of acclaim and recognition at the very top of their field. So USCIS likes to say they're at the very top percentage of their field. They have to demonstrate extraordinary ability in their field, evidenced by sustained national or international acclaim, which can be proven through letters of attestation from other experts in the field, and then receipt of nationally or internationally recognized prizes or awards, similar to the outstanding professors and researchers. You can also show show that through membership in associations that require outstanding achievements, published material, scholarly articles, participation as a judge of work of others, original contributions. You can also show that they make a higher salary in their position. So basically that their level justifies a higher salary, that they are in a leading role with a distinguished organization, etc. So the difference with individuals of extraordinary ability is that they do not require a job offer. So this one, I mentioned earlier that there are limited exceptions for the employer sponsorship piece, meaning that the green card's tied to an employer or a job. Since an employer does not have to sponsor it, the individual can actually self-petition, and we get this a lot where employers are not ready to sponsor for them yet, or they don't sponsor in their immigration company policy. The employee will actually go self-petition all by themselves with an attorney and prove that they are an individual of extraordinary ability. They are supposed to work in their field of extraordinary ability when they get their green card, but it's not tied to a specific employer. And then the other benefit of this preference category is that's only a two-step process. So you skip the labor market test, which is nice because it's the most costly part of the process and the most time-consuming. So you get to go straight to the I-140 immigrant visa petition, either with the employer sponsored, if it's one of these three, or the employee sponsored themselves, self-petitioning under the individual of extraordinary ability. And then once their priority date's current, they proceed to I-45 or the immigrant visa interview at the consulate. EB2 is for advanced degree professionals in exceptional ability. So the employee has to possess an advanced degree and the position must require it. So advanced degrees like a master's degree, PhD, or any level above that. You can also substitute it as a bachelor's and 5 years of experience to equate to that master's level. So if your position minimally requires a bachelor's and 5 years of experience and the employee has that, then it could qualify as an EB2, as long as they acquired that experience and that education level before they started their job with you. There's also a subcategory in EB2 for individuals of exceptional ability. It's very similar to the one that I just mentioned about extraordinary ability, except it has a lower standard of proof. And there's also regulations set out for the criteria of exceptional ability. And you can also skip the labor market test if sponsoring for someone as exceptional ability. You can also skip the labor market test if the employee is going to be in a position that the government has already deemed as one in the national interest. So it's exactly what it sounds like, national interest waiver. They allow you to waive that labor market test by proving what they're doing is in the national interest, and there are several criteria there. These have gotten a little stricter in the last few months, but there is preference given to STEM higher degree holders. And then also there are certain occupations that are automatically deemed in the national interest, so you don't have to make that case to the government. It applies to physicians and physical therapists that fall under the EB2. It's called EB2 Schedule A for some of them. But then physicians there's a physician national interest waiver. So you don't have to make the case necessarily. You just have to show the regulation that says there's already been a predetermined shortage of physical therapists in the area, so you can proceed straight to step 2. And then physicians have their own set of requirements under the physician national interest waiver, where they're agreeing to work for 5 years in an underserved area in order to waive that labor certification requirement. For EB3, again, these are for employees who possess the 4-year university degree and the job offered has to require that degree, or it's for folks who possess a minimum of 2 years of experience and the position has to require a minimum of 2 years of experience. And similar to EB2, There are certain occupations that automatically are deemed as a shortage of occupations. Specifically, nurses will fall under this category. Again, it's called a Schedule A. And they can skip the labor certification process. If it's a nurse that requires more than a bachelor's degree, so if not a traditional nurse, but more like a clinical supervisor nurse or similar to that, then they can fall under EB2. But otherwise, government has already deemed that to be a shortage of occupation, so you don't have to prove it by going through the labor market test. So finally, what are some best practices for you as the employer? You've heard me talk about how long the green card process takes, especially if you have to go through step 1. You've heard me talk about the backlog, especially for folks who are born in China or in India. So the message is really to our employers is to act proactively and prepare for delays. So because the green card process can take a really long time, it is prudent to take a look at and audit your foreign national employees, talk to your departments, talk about those who are so important to retain for all the reasons that I mentioned before, and looking at their visa maximum status. And start the green card process for them sooner than later. Most of our employer clients, it depends on who it is, but our overall recommendation is to start that process when you are 4 years away from the employee's temporary visa max out. But best practice is after 1 year of employment, assuming they still have their full non-immigrant status, because again, it's just taking too long, and depending on their country of birth, you might even want to consider sooner. Be aware that dependent children, they might age out, which is really sad to see with some employees, those from India and China specifically, because they have such a long wait. The children are not necessarily locked in if the parents started the process, when the child was 10, 11, or 12. They have to get to that last step of the process while the child is under the age of 21. So because of the 10+ year wait for folks born in India and China, you as the employer, and we've seen with a lot of our company clients, they have India and China national employees come into them and asking them to start sooner, or they might go out and try their own self-petition in a quicker category like EB1, just to try and get their children, ensure that their children can tack onto their green card process with them before they age out, meaning turn 21. I cannot stress this enough, but developing an immigration policy is so crucial for employers. It's really crucial for those, if you're trying to strategically manage your workforce and then remain competitive in a global talent market, because having a sponsorship policy is going to allow consistency and fairness. It allows standardized processes that are going to ensure a consistent and fair approach to sponsorship decisions. It gives transparency to your employees by clearly communicating criteria and procedures, which also in turn helps manage employee expectations and, of course, promote trust within the company. So if you don't have one, we help our employers and clients develop them, or we review them on an annual basis, and talk to our clients about what we're seeing with other clients in their industry and of their size, again, in order to stay competitive. But there are some things to consider. Of course, payment of fees. What is industry standard? We're asked this all the time. What do I have to pay for, and what does the employee have to pay for? As a general rule of thumb, it's really up to you, but as a general rule of thumb, step 1 of the green card process must by law be paid for by the employer. Every single piece of that step has to be paid for by the employer. The rest of it, there's no rule about who has to pay for it. So some of our clients, they have the employees pay for step 3, which is really just their application to the government. Some of our clients, they'll have their employees just pay for family members. Some clients pay for all of it. It really just depends on you as the employer, what the budgets are. It can depend on the department as well, but it is something to consider. And again, outlining it in that policy and outlining it in that policy, and then making sure it's transparent and clear and consistent. Another thing to consider is when to start the green card sponsorship policy and outline this to be transparent and manage employee expectations. I mentioned before, many employers, the longer it's getting, we're seeing them start it after 1 year of employment. Again, that gives them some time to evaluate performance and trust, make sure it's a good fit for everyone. But some want to wait. The longest that I would wait personally is when you've got 4 years of status left in the non-immigrant status. And again, just communicate those policies clearly, apply them consistently in the policy. When you're onboarding folks, give them a copy of it, have them review it, have them sign it, confirming that they acknowledge and review it. You can have a payback policy too, except for that step one. So if they're going to leave after they've gotten their green card or within a certain period of time of having their green card, you can ask them to pay back and agree to pay back a percentage of those fees that you've already paid for them, except for step one. Another best practice is maintain underlying non-immigrant status where possible. Again, that is so that means like maintaining the H-1B, the L-1, the TN, the O-1, whatever the non-immigrant status is, maintain it, keep extending it until they have the green card, because if something were to happen with the green card, or if the wait times get longer and longer, if the processing times for the work permit under the green card, while you're waiting for the green card, take longer, then you at least have that non-immigrant visa and status to fall back on, and again, just avoid or limit any disruptions in operations. And then finally, of course, call an immigration attorney, ask a professional when in doubt. There is a lot going on in immigration right now with a lot of policy trickling down, a lot of enforcement. It is a very challenging time in immigration, including for employment-based. So just find your partner in the immigration law field and ask them whenever you need something. And if there are any questions, I'm happy to take them. Otherwise, here is my contact information and our firm's contact information.
Awesome. Thank you so much, Colleen. We did actually have 2 questions that came in, so I'll go ahead and shoot this over to you since we have a couple minutes here left. So the first one kind of piggybacks off one of those last things you just said, which is there's a lot of changes coming in immigration law, and HR professionals are probably scrambling a little bit to try to keep on top of it. Other than reaching out to a lawyer when they need, that specific advice, is there any other resources or newsletters or anything they can reference to kind of just keep a pulse check on all of the changes?
Yeah, good question. I know, I think SHRM has some good resources, and if you don't already have a good partner in immigration who's providing newsletters, I would suggest you look around and try to partner with an attorney or a firm that helps you stay abreast of everything that's going on with client alerts and newsletters. If you go to our website right here, there's a button to sign up for client alerts and newsletters. So when everything's happening, we try to get that news out as quickly as possible. But other than that, I think SHRM is probably, I've heard, a good resource. Yeah.
Perfect. And is there documentation that HR should be keeping, and about how long should they keep those any of this kind of process as they're working through it?
Yeah, so it depends on what you're filing. And for non-immigrant visas, there are certain documentations files that you have to have available for public inspections and audits. There's nothing really similar to that or parallel to that from the green card perspective. But as the attorney, we are the ones really keeping a lot of that on file for you. There's an audit file that has to be ready to go to the Department of Labor after filing the PERM application if the Department of Labor wants it. So your attorney should have that on hand and on file. If you have a sponsorship policy as well, I would keep those on file, especially acknowledgement from the employees that they've read it and they agree to it, and especially if you have a payback policy as well.
Great. Well, thank you so much again, Colleen. It was incredibly insightful, and we really appreciate you taking your time today to share your knowledge and expertise with us all. Thank you to our audience for joining us for retaining foreign national talent. I hope you found Colleen's information valuable as you continue to support your teams and navigate these very complex waters of immigration sponsorship. We'd love to have you all join us for upcoming webinars and lunch and learns. You can find that all of our future events on our page in the link that we've dropped here. But thank you again, Colleen. Really, really appreciate it. And I hope everyone here has a great rest of their day.
Thank you. Thanks for having me.
Thank you.